said the other day, and I believe these are your words, if the court rules in favor of gay marriage, it would be open season on people of faith.
Absolutely.
I mean, how can you say that?
Oh, I can say it very clearly. When this is what's at stake here, Bob. This is not about the marriage altar. This is about fundamentally altering the culture. Just on Friday.
All right, ladies and gentlemen, I apologize for the technical difficulties. We were in the middle of hearing Tony Perkins' answer to the question from Bob Schieffer about the Supreme Court of the United States, which today heard oral arguments for about 2.5 hours on the issue of gay marriage, cases involving the states of Kentucky, Michigan, Ohio, and Tennessee. Now, it was very interesting. Those who were in attendance are saying that the Supreme Court is divided on this issue, as you might expect they'd be divided. Most interesting, of course, is the person that everybody considers will be the justice that will be the swing vote, and that is Justice Anthony Kennedy. Anthony Kennedy asked why it would be appropriate for the court to change the definition of marriage that, quote, has been with us for millennia. But then he also went on to bring up how not okaying gay marriage might affect the children of gay couples. So what's stronger in his mind? Changing the culture, changing, as Tony Perkins said, the accepted culture as it's been forever, or giving those kids official status of having married parents. Look, folks, you know how I feel if you've watched or listened to me for any amount of time, whether here at Newsmax TV or in my other career as a talk radio host. You know how I feel. I think traditional marriage is what marriage is. If you want to have gay people get together, you could call it something else. But it wasn't me. It was Sonia Sotomayor, don't forget, last go-round on gay marriage in the oral arguments before the Supreme Court of the United States, who asked the question, where would you draw the line? Now, it didn't stop her from voting for gay marriage, but she brought up, where would you draw the line? Polygamy? How many people could get married? That wasn't me. That wasn't a right-wing lunatic talking point. That was Sonia Sotomayor. And I think it's a legitimate question because you might say to me, well, who are you to say two people in love can't get married because they're the same sex? Well, then I'll say to you, who are you to say 3 people or 4 people can't? And you'd say, oh, that's ridiculous. No, well, to me, 2 gay people or 2 lesbians is ridiculous because marriage is between a man and a woman. And I have a problem with the courts sticking their nose into it when the people, time after time after time, when they vote, have voted either through their own pulling of the lever or through their state legislatures to keep marriage traditional. The definition in their state is between a man and a woman. Then along comes a judge and says, oh, too bad, you're not going to keep that. And guess what? Then everybody says, oh, another state wants gay marriage. No, it's not the state. It's a judge somewhere along the line. All right, joining us now to debate this or give us her opinion certainly is Gloria Allred. You know her, famous attorney. I'm sure I'm not stepping over the line by saying feminist and discrimination attorney as well, fresh from watching the Supreme Court gay marriage hearing with her clients. Gloria, welcome.
Thank you very much for having me. It's been an exciting day, and I was in the courtroom. I'm a member of the Supreme Court bar, so I had a good seat towards the front and could hear the arguments. And it was, of course, I filed a case in 2004. I announced that in California that if my clients, a same-sex couple, were denied a marriage license, that I would file a lawsuit and challenge the ban in California. I did, fought for 6 years, twice to the California Supreme Court. We won the right for them to marry. So we were very interested in the questions before the court today, and I was here with my clients. And so, but I mean, I would take issue with you respectfully, so because you left out a very important word, and that is the Constitution of the United States. So, I mean, one of the questions the justices did bring up, and they do have to decide, is who decides this issue? Is it decided by the voters? Is it decided by the state legislatures? Or is the court going to make this decision? The anti-marriage equality group argued, well, this is a democracy. But as Justice, I think it was Sotomayor pointed out, this is not a democracy. We have a constitutional democracy, which means there are rules. We have to look at the Constitution. I mean, the United States Supreme Court in the past has found that marriage is a fundamental right guaranteed by the 14th Amendment to the United States Constitution, because the Due Process Clause guarantees liberty to all of us, and liberty encompasses the fundamental right to marry. Now, I would argue, what's the point of having a fundamental right to marry if you can't marry the person of your choice? That issue didn't come up in the court today, but they did argue about who should have the right to decide. The Supreme Court of the United States did decide in 1948, Loving versus Virginia, which was brought up in court today. They did strike down the state bans on interracial marriage at that time. And now they're being asked to strike down as being unconstitutional bans on same-sex marriage. I frankly don't see that much difference.
Well, Gloria, there is a difference. One is between a man and a woman, and the other is between two men or two women. There's a fundamental difference. One was a racist policy, and the other one fits the traditional definition of marriage that has existed in every society from the beginning of time until now, as brought up by Justice Kennedy. I think it's an obvious difference.
But also, as brought up today, racial segregation was also a tradition in our country, but that was struck down.
All right, let me ask you, Gloria,
in Brown versus Board of Education.
Okay.
So just because something is traditional doesn't make it right.
Well, okay, fair enough, but let me ask you this. People have a right to marry the person of their choice, so let's not bring up 3 people or 4 people. Let's keep it with one person. Can a brother marry a sister? And if not, why not?
Well, there are exceptions, and that.
Why? Who says there are exceptions?
Well,
if it's a constitutional.
That was actually discussed in the United States Supreme Court today.
Well, go ahead. What'd they say?
And for example, and one of the counsel arguing to the court was saying, well, there are a few state exceptions. For example, incest. No.
I'm not talking about incest. Let's say a 65-year-old man.
Marrying a sister is incest.
No, a 65-year-old man and a 70-year-old woman. They've never been married. They're brother and sister, and now they see everybody's getting married, and they want to exercise their constitutional right, as you put it, to marry the person of their choice. Who are you to say they shouldn't get married?
No, that is very different, and we're not talking about that.
Why is it very... Gloria, explain to me, with all due respect to you back, why is it very different?
It's very different because it doesn't involve what we call consanguinity. If I'm saying it correctly, marrying a blood relative, to put it in plain English, which, no, that is not permitted. Incest is not permitted.
But there's no incest.
We're talking about 2 consenting adults, and the question really is, should they be excluded, shut out of what we all agree is a noble institution, a fundamental right, the right to marry?
You're making my case. So why can't the senior citizens, brother and sister, who have never been married, who have lived together their whole lives, why can't they get married? They're not going to have sex. They're not going to have kids.
Well, wait a minute. Just because you're in your 60s
all right.
and 70s,
so they're having sex
anyway.
So if they're going to have sex, they're having sex anyway. They can't have kids.
Let me tell you something. A lot of people in senior citizen homes who are having a whole lot of sex.
All right, but they're not having kids. They're not having kids. So my point is.
Okay, but that's not the only purpose of marriage.
No, but you said it's a constitutional right. So why do we deny them?
No, but I'm saying.
Because you think that goes over a line. I think this goes over a line. What's the difference?
It isn't necessary to commit to procreation in order to get a marriage license.
Right.
So that is really not the point. And the real question is, there are 2 questions. One, do they deserve? We have a constitutional a provision in the 14th Amendment which guarantees equal protection of the law.
For the brother and sister,
There's no equal protection of the law for same-sex couples. There's a history of discrimination against them. They are a minority that has been humiliated, who have been subject to acts of violence, who have been discriminated against, who have been, treated as second-class citizens.
All right. So what do you think, Gloria? What do you think the court? What do you think the court's going to decide? 5-4?
I think it could be a 5-4. It could be even a 6-3.
Okay.
If it's 5-4, then Kennedy is the swing vote.
Right. All right, Gloria. Great to talk to you. Thank you so much for coming on. Appreciate it.
Thank you.
Bye-bye. Colin Flaherty is next, folks. We're going to talk Baltimore.